And right out of the gate, DWI plus evading arrest, this morning docket is already heating up. Pay attention to how the judge sets the tone here. Calm voice, serious consequences.
Good morning, Mr. Salis. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You're also charged with evading arrest or detention. On that, you're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
On or about March 26, 2025, an officer was on patrol on Gulf Freeway.
Quick legal note. Multiple disabled vehicles, airbags deployed, tires shredded. This sounds like the aftermath of a high-impact collision. But remember, in court, damage alone is not proof of who was driving. Watch how this becomes the defense's central argument.
In Harris County, Texas, the officer observed a motor vehicle disabled in the left hand with grass speeding, dividing southbound and northbound lanes of traffic. The motor vehicle had multiple airbags deployed and all 4 tires appeared to be damaged. Upon arrival, the officer observed additional motor vehicle disabled on the open access roadway of what was formerly a car dealership. The officer observed the witness walking towards the officer, trying to get the officer's attention. The witness said that 5 minutes prior to the officer's arrival, the defendant approached the witness after the witness tires were blown out. The witness informed the officer that the defendant demanded to use the witness's phone. The witness advised the officer that the defendant wanted to contact the defendant's mother to pick up the defendant from the scene. The witness told the officer that the defendant continued to approach aggressively and that the witness told the defendant the witness would call the police if the defendant did not stop. The witness said the defendant fled the scene on foot. The witness described the defendant's clothing, and the officer observed the individual matching the description of running and approaching the scene of the incident. As the defendant approached the scene of the accident, the defendant began walking in a parking lot adjacent to the freeway. The officer gave loud verbal commands for the defendant to stop. The defendant fled on foot on the grass along a ditch. The defendant slid down a ditch and the defendant crossed the creek, then climbed the fence attached to a private residence, and fled on foot for approximately 0.4 miles before he was then detained by his police department and turned over to deputy. The scene was moved to a Shell station to continue the investigation. The officers contacted the defendant. The officers observed a strong odor of alcoholic beverage emitting from the defendant, and the officers observed the defendant have red glossy eyes, slurred speech, dry mouth, repeating phrases, and agitated demeanor.
You say a shaky demeanor?
Sorry, agitated demeanor. And the defendant denied drinking alcohol and initially denied drug use, and then stated that he had been off for a couple of days and had consumed paste or coke. The officer, through training experience, noticed to be represented cocaine. The defendant admitted that he was going to a girl's house when the incident occurred and agreed to perform the standardized field sobriety test.
Here comes a defense attorney, and listen closely. He zeroes in on the one thing prosecutors must prove in a DWI case: operation of a motor vehicle. If they can't show you were actually driving, the whole thing can collapse. This is where the battle really starts.
Those were administered, and the officer observed success exclusion on the HGN. The officer did not administer the walking turn of the one-leg stand due to the defendant injuring his feet while fleeing. The defendant consented to a breath sample, which was not completed due to interference being detected. The officer obtained a search warrant for the defendant's blood, and there was a blood draw for the defendant.
Okay. Your Honor, may I come?
Please.
I might have missed something, but besides state saying that my client said he was going to someone's house, I didn't hear any operation facts.
I mean, he admits driving. He's by the car when the officers get there, right? Is he by the car when the officers get there, or where is he?
From what I have, Your Honor, he has fled the scene when the officers get there, and then comes back to the scene.
Okay.
To the officers. The witness.
Does the witness put him operating at all?
Yeah, just one moment, Your Honor.
Take your time.
Yeah, all I heard is going somewhere. It doesn't say he was driving anywhere.
Sometimes obviously the DUI, they might refollow, but might have been the wrong corner. Sometimes they'll fade in, it's getting to go.
I'm not sure, Your Honor, there was anything additional. This is kind of like this mirror.
Hey, good in.
See you again, Your Honor.
Yeah, what's up, man? Good to see you. Do you have anything else?
Your Honor, it does look like the witness stated that he stopped and exited his vehicle and observed the driver of the RAV4. That's what I have, but
So it doesn't match up with my client.
Kaiser Bono, Martinez stated once he stopped and exited the vehicle, he observed the driver of the RAV4 identified as.
And finally, an admission. He says he was driving. But, and here's the twist, an admission alone often isn't enough. Courts usually want an admission plus something else to confirm reliability. This is why the judge starts leaning toward no probable cause. Stay locked in.
Abraham Elias Salis, using driver's license, come out from the grass near the RAV4 and aggressively approach him, requesting to use his cell phone. Stated that he was trying to use his cell phone to call his mother to come pick him up, and that Salis said the RAV4 belonged to his mother. Martinez stated after a short time that Salis asked Martinez if he had papers for immigration.
Judge, even with these facts, it doesn't show driving. Even if he owned the car, we have no idea when. There's no facts to say that he was driving the car, that he admitted to driving the car. I don't see operation still.
So Salis stated that he was driving the RAV4 because he was going to a female's house and continued to speak. Salis then stated that he ended up in the grass because he was scared. Then stated that he was a Mexican driver that swerved in front of him and allegedly
He said a Mexican driver swerved in front of him. Is that what he said?
told him no Tango Papeles or I don't have papers. Salis said the other driver was in a gray Toyota telling him to go away. Stated that the RAV4 and the alleged Toyota came into contact, causing a collision.
This is the moment everything turns. Right here, the judge is weighing the totality of the evidence. And despite the chaos, the admissions, and the witness statements, the missing puzzle piece is still independent proof that he was behind the wheel at the time. Watch what the judge decides.
Salis stated that he was coming from his house in Friendswood, but denied having anything to drink. So
I mean, I think if
he
they,
was operating the vehicle at the time of the accident.
and you have,
That speech? Classic judge move. Even when dismissing probable cause, they deliver a reality check. Hard. It's both a warning and a lesson for anyone watching. Beating the case doesn't mean beating the consequences of risky behavior.
the other person say something, right?
they say that it was, they identified him as the driver.
They just never say they saw him driving or operating the vehicle.
So I believe that they believe, based on the circumstances, that it was a driver. I don't know if the witness actually saw him driving, but we have to prove the driving facts is that Reeves got fired to believe prior to his arrest. He admits that he was driving the vehicle at the time of the accident, and the vehicle was found at the scene of an accident. He was found nearby. Was observed coming out of the grass nearby. We by the driver.
Although it's an admission, Judge, it needs to be an admission plus. I don't see that being enough for the plus.
Mr. Salis, I'm going to find that there's no probable cause in your case. Every freaking day in our county, someone dies from an alcohol-related collision. Don't become a statistic because of a boneheaded move that you make where you kill someone. Do you understand? Now, I'm going to find no probable cause. It's very possible they go indict this case at a later time if they get more evidence. But don't kill anyone. Do you understand?
Yes, John.
See.
Thank you. Are there any conditions you're imposing on the evading case?
No, I'm going to find no on both.
On both. Thank you, Judge.
Talk to me.
Desnick Smith. He's one of the ones that,
Yeah, ones. Okay. What's the last name?
Smith, Desnick, what did you do? Out of Louisiana, one of those four guys that you already talked about. He's the one that did not have he was a passenger, not the one with the weapon.
There were 3 passengers.
I talked to his mother.
How old is this kid?
He's awfully young. I can't, he has a computer, I don't. He looks awfully young. I talked to his mother. His mother's willing to post bond and able to post bond if it's reasonable.
Therein lies the question. What is reasonable? Right.
1,500 would be reasonable.
He's coming back in.
I know. Nelson, did they respond?
What's that?
Did they respond on Nelson?
Smith, please, bring up Mr. Smith.
Okay, yeah, we're on Smith.
Okay.
Smith's coming out now.
Black claims that they told them they were not going to mess with it. We're still waiting for the official word from, Florida. What's the name of that city?
I don't know that, I just went by the county.
It's another one of those.
I've been mispronouncing,
Natchitoches.
I've been mispronouncing
I
county.
know.
Morning, Mr. Smith. How's jail?
The worst experience of my life, bro.
Makes me really happy. It's supposed to be, you know? The idea of jails are that you learn, and unfortunately, we have people that just don't get it. No matter how long the sentences are, no matter how cold the bars get, they just don't get it. You're wanted out of Louisiana for this, this car.
Yes, sir.
Your lawyer's asking for me to set you a bond, but I don't know. I've never met you before. I don't know you. You know, one of the things that I consider is, number one, are you going to go back if we set you a bond? Number two, are you a dangerous person? Because I don't want to set you a bond and then you leave a wake of destruction on your way to Louisiana. I mean, I don't want that.
Yes, sir.
So, Mr. Kim, tell me about Mr. Smith.
Your Honor, this now defendant, along with 3 co-defendants, stole a vehicle out of Louisiana and transferred state lines on the same day and was apprehended in Harris County. He's facing a felony charge there due to the fact that they transferred state lines within 24 hours of stealing the vehicle, which was captured on surveillance video. State would be opposed to a bond as state considers him a flight risk.
Any prior criminal history?
No, Your Honor.
Judge, he is from Natchitoches, Louisiana, which is where the offense is from. His family lived there and he was born there. They moved to Manning, Louisiana. I talked to his wife and his girlfriend.
His wife?
Mother.
23?
That's what I
His
call it.
mother and his girlfriend. Okay. I spoke to his mother, Sophia Smith. She lives in Manning, Louisiana. She will post his bond. And I spoke to Sophia Smith and she'll come over and pick him up. That's, and transport him back to Louisiana.
Here's the thing, Mr. Smith, is I need you to understand that we don't play games. If I set you a bond and you make that bond, we give you 2 weeks to go turn yourself in.
I will, sir. I promise.
We don't play games. So if you fail to do it, I'm going to revoke that bond. I'll set it at 0. I'm going to issue a nationwide warrant for your arrest. I'm going to get you because you can't run forever. And the next time, you will not get another one. Do you understand? Okay. I'm going to set you a bond at $1,500. Here's the other thing. Life is short. Life, when you end up with a bunch of convictions, it doesn't become a fun life. What makes life fun is you get knowledge. And when you get knowledge, you buy things because you get money. But you only do that when you go out there, school, learn, get a good job. That's what life is about. I'm not picking up convictions.
Sir, that's nothing. I'm in college right now too, sir. That's why it's kind of crazy. I'm
Really in college?
for audio arts.
And now with all this, really? Dude, when you hang with boneheads, it doesn't end up well, you know? Get a clue so you don't end up back here. Mr. Smith, I'm going to set your bond at $1,500. Just, Mr. Smith,
Yes, sir.
don't disappoint us, man. Do something with your life. Don't become another statistic. $1,500 and then do right, man. It's not hard in this life, you know? All right, we got you, buddy.
Thank you, Judge.
So if he can make it, I'll print out the reset for him to sign and I have the waiver withdrawal for you to sign. 'Cause he's-
I'll bring that. Don't send him back yet. You got some.
Yeah, so I'm typing up the reset right now, but the waiver withdrawal is there for you to sign.
You're Jeffrey Chauvin.
Yes, sir.
Mr. Chauvin, you're charged with criminal trespass. You're also charged with resisting arrest. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay, please.
On March 5th, 2025, an officer was dispatched to a trespasser call at a Whataburger in Harris County, Texas. Complaining witness and employee stated that she told the defendant who was in their dumpster in the parking lot to leave and the defendant refused. Staff tried to tell the defendant to leave again at 1 a.m. and defendant stated that he would leave in an hour. At 2 a.m. and 3 a.m., defendant was still refusing to leave after being asked to do so multiple times. At 5 a.m., the trash company came. Defendant refused to come out so they could not pick up the trash. The officer observed defendant in the dumpster and asked him multiple times to come out and that he had been trespassed from the location, but defendant continued to refuse for about 30 minutes. The officer asked the defendant if he would be willing to go to the jail diversion center, and defendant said yes. The officer handcuffed the defendant so he could eat food. Officers provided him. The officer went to reapply handcuffs, but the defendant resisted passively by not following officer commands to lean forward. The defendant verbally stated, "No, I'm going to keep my hands here." After several attempts and the defendant not following verbal commands, the officers removed the defendant from the vehicle and put him on the ground so he would not hit his head. While officers attempted to handcuff the defendant actively resisted by pulling his arms away from officers. The officers still took the defendant to the jail diversion center, but upon arrival, the defendant said he did not want to be there and just wanted to be released, so he was rejected. While en route, the defendant had taken his seatbelt off, put his handcuffs in front of his body.